Good afternoon, colleagues and distinguished participants. It's an absolute honor to be here with you to open this important session under the South African G20 presidency. As you all know, the theme guiding the South African presidency of G20 is solidarity, equity, and sustainability. And it sets a clear direction for how we, as nations, but also as competition authorities, must approach our shared global challenges. These principles are not abstract ideals. They are the foundation of a people-centered future where every nation, and indeed every citizen, has a fair and equitable access to opportunity. The G20 trade and investment track recognizes that the world is becoming more fragmented. Globalization's benefits have not been evenly distributed, and many regions, particularly in the global south, have borne the brunt of its adverse effects. The work before us today of understanding how competition policy contributes to inclusive and sustainable development is central to reversing these trends. Competition policy, as we all know, stands alongside trade and industrial policy as a key lever to shape fair, dynamic, and resilient markets. I believe it is through effective competition enforcement that we can ensure equitable access to markets, protect consumers from harm, and encourage innovation that serves broader developmental goals. For South Africa, this link between competition and development is fundamental. At our recent internal strategy session, the Commission reaffirmed its commitment to aligning our work with the broader goals of inclusive growth, industrialization, employment, and poverty reduction. These are not just strategic aspirations, they guide our enforcement actions and policy advocacy. We constantly ask ourselves whether our outcomes are delivering tangible and relevant results for the people of South Africa. Whether interventions are expanding opportunities for historically disadvantaged persons who would have been excluded in the past, and small and medium enterprises, building resilience and promoting fairness in the economy. The timing of this discussion is particularly appropriate given that the Competition Commission will soon this week release its final report on the media and digital platform market inquiry, reflecting an intensive investigative process into digital platform markets, news media, advertising, and the role of innovation in our economy. That report underscores how competition policy interacts with digital transformation, inclusion, and the public interest. These are precisely the themes we will engage in this workshop. It reminds us that our work is not only forward-looking, but grounded in concrete facts, and that our enforcement choices must deliver for all our people, including people in South Africa today, as well as set the condition for future generation. In this context, today G20 competition workshop offers an important opportunity for reflection and collaboration. As competition authorities, our jurisdiction may be national, but our impact is undeniably global. The firms we oversee, which are often the world's largest multinational, operate across borders and influence markets that are critical to the global commons: food systems, healthcare, energy, technology, and climate sustainability. Our enforcement choices matter beyond our borders. They shape the incentives for businesses, they signal what conduct will not be tolerated, and they can reinforce or undermine global efforts towards sustainability and inclusion. This means that greater cooperation and alignment among G20 competition authorities is not only desirable, but necessary. Through this workshop, I hope we can explore how to better coordinate around these shared objectives. How can our enforcement decisions collectively promote sustainable industrialization and fair digital markets? How can we ensure that competition contributes to green innovation, to fair global trade, and to the reduction of inequality both within and between nations? These are not easy questions, but they are the right ones, and this forum gives us a valuable space to engage with them. I'm confident that the dialogue today will help us chart a clearer direction for how G20 competition authorities can contribute meaningfully to the global sustainability agenda. Thank you, and I look forward to the discussions ahead. Allow me, though, to introduce the next speaker. She is the head of the Competition Authority of Mexico, but she's also the chair of the International Competition Network. She is a friend, and her name is Andrea. Andrea, welcome, and thank you for joining us, and we look forward to hearing from you. Thank you.
Thank you, Commissioner Shepe. Thank you for this invitation. It is. There we go. Sorry. Thank you, Commissioner Shepe. It is my pleasure to be here. Good, very early morning in Mexico. Good afternoon and good evening to all of my colleagues. As Commissioner Shepe mentioned, I would like to briefly share with you some experiences from the Mexican perspective as the head of the Mexican Anti-Monopoly Commission, but also some international perspectives. Let me just start from the Mexican point of view. So as some of you might know, the Competition Authority in Mexico has undergone significant and recent changes, both by a constitutional amendment, which was published in December last year, as well as an important reform to our competition law, which was issued in July this year. These two events have implied a transition from COFECE, or the Mexican Federal Competition Commission, to a new competition authority, the National Antitrust Commission. As of today, the new board has been officially appointed, and the new authority has started operating since October 16th, so just 3 weeks from now. Amongst the most important changes to the now CNA, or National Antitrust Commission, the CNA will now be the sole body responsible for enforcing and applying competition law. We used to have two bodies. One was in charge of all of the sectors across the Mexican economy except telecom and broadcasting. And as of today, we have a sole competition agencies. In the discussions that were made when these changes to the law and to our constitution were made, we also agreed, as Commissioner Shepe, and we conveyed the message of the importance to align competition policy with broader public policy objectives within the federal government. Hence, now, as a new competition agency, we can expect closer coordination and collaboration between the CNA and the federal government to ensure and help and foster that competition policy is embedded in a broader economic strategy. This, I think, is essential if we want to be efficient, dynamic, and fair markets and inclusive to truly serve consumers and, as Commissioner Shepe said, to give tangible results. Competition policy cannot live in isolation. I think when we look at competition policy, we can divide it in two. If we look at competition enforcement in our investigations, in our merger review, these have to be very technical, independent studies and proceedings. But when we look at other functions and other points of competition policy, such as advocacy, there, competition agencies have to have a strong, collaborative, and constant dialogue with other policymakers in order to help competition principles be embedded in other policies. Our new law has a very broad scope, and even though the substantive part of the system remains practically untouched, that is, investigations and merger review, the new law does include some relevant improvements that can strengthen the authority's position. For example, a significant increase in sanctions for anti-competitive conduct and unnotified mergers, which strengthens the deterrent effects in our competition law. The introduction of new sanctions, such as the disqualification of companies from public procurement for colluding, the strengthening of investigative tools, particularly through expanding mechanisms for information sharing and gathering and cooperation with other national and international authorities, and but also the simplification process for filing class actions, for claims for damages to compensate consumers who have been affected by anti-competitive conduct. Let me just give you one example within the Mexican context, and maybe two. I'll be very quick. The first example is related to a recent market investigation that we conducted in the car payment system. Within this investigation, we concluded that there were significant barriers to competition in the car payment system. But we didn't stop there. We didn't just, and these barriers, most of them, were a result of regulatory barriers and of regulation and how regulation in Mexico works regarding interchange fees and regarding clearinghouses. And what we did is we didn't just stop after the market investigation. Once the investigation was done, we engaged in a very collaborative and constant dialogue with the financial regulators in Mexico. And this has now resulted in the change of these regulations. Currently, there is a public consultation underway of changes that are being made to the financial regulation that answer precisely to the barriers that we found in the car payment system. Another example is related to the distribution of medicines, of pharmaceutical products. Years ago, medical distributors were sanctioned for colluding in prices and market allocation while selling medicines. They were fined with very high fines, but we didn't stop there. Less than a year ago, a few months ago, COFECE, the competition agency, filed the first ever class action against those medical distributors. Class actions, I believe, is another key point which helps make competition benefits tangible, because you don't only sanction the companies who violate the law, but you actually repay consumers the price that they overpaid due to collusion and to anti-competitive practices. Finally, from the international perspective and cooperation, I could not agree more with what my colleague and dear friend, Commissioner Shepe, stated. I think looking ahead, one thing is absolutely clear. International cooperation among competition authorities will not only grow in relevance, but also in complexity. The challenges that we face today the challenges that we face today are simply too interconnected. There we go. Can you hear me? Good. Okay. So the challenges that we face today are simply too interconnected for a single agency to tackle it alone. That is why competition cooperation is not optional. I think it's essential. We are witnessing a worldwide evolution of competition law and policy. Mexico is no exemption from it. And agencies are now reevaluating their frameworks, reassessing their tools, and engaging with new cross-cutting issues such as digitalization, as Commissioner Shepe just stated an example, or the intersection between competition and industrial policy, which is also that was mentioned by Commissioner Shepe. So platforms, international platforms, where competition agencies can engage, interchange ideas, methodologies, etc., allows agencies to exchange our experiences, to learn from one another, and to build common approaches to share challenges. This dialogue, I think, is what allows us to stay ahead in a very fast-changing world and to face the challenges of our economies. Looking forward, international cooperation has to become and is becoming more practical, more inclusive, and more responsive to the realities of today's complex geopolitical and economic landscape. Strengthening cooperation with both bilateral and multilateral organizations is a strategic priority for Mexico, fostering effective competition policy and efficient markets that are inclusive and that make benefits tangible to consumers. As Commissioner Shepa mentioned, I was recently honored to be appointed as chair of the ICN steering group. In this role, I am committed to advancing on the ICN's mission of fostering stronger collaboration amongst members. The ICN has evolved almost for 30 years, for more than 25 years, as a well-established and impactful organization, one that not only has to facilitate the exchange of ideas, but also cultivates a community that supports agencies from different perspectives, with different points of view, with different legal systems, in addressing shared challenges and identifying common solutions. The ICN has to deliver and will continue to deliver tangible value by providing a platform to share knowledge, enforcement experiences, and best practices. This exchange enhances our work within our jurisdictions while contributing to the global development of competition policy. In the context of this G20 workshop, Mexico experiences, or we try to bring on, how enforcement choices can be aligned with broader policy objectives and how strengthened cooperation amongst the G20 competition authorities can also help us collectively shape markets that are not only efficient, but also resilient, inclusive, and sustainable. So let me just end this intervention with conviction. I think that together we can make competition policy stronger, more agile, and more impactful for our economies, for our businesses, and most importantly, for our people. Thank you, Commissioner Shepa.
Thank you, ICN Chair Andrea Marban. I'm the moderator for today's panel. My name is James Hodge. I'm from the Competition Commission of South Africa, the Chief Economist. And I want to thank our Andrea and also our host country, G20 country, South Africa, Commissioner Doris Tsepe, for those introductory remarks. We have an interesting panel lined up from different corners of the globe. And let me just introduce them before we get stuck in. We have Mr. Malik Diallo, the head of competition division at the African Free Trade Area Secretariat. We have Ms. Tatiana Lima, the assistant chief economist at CADE Brazil. We have Dr. Luca Arnaudo, the senior officer at the Italian Authority. We have Mr. Andrei Siganov, the deputy CEO of FAS in Russia, and Dr. Hisham Alugil, the Deputy CEO of Economic Affairs in Saudi Arabia. I would like to welcome our panel. And before we get stuck in, I thought I would just set out the context. As set out by Commissioner Tsepe and the other Commissioner Marvan, the challenge really being put out to the G20 competition authorities is whether they should play and can play a more deliberate and coordinated role in addressing some of the global challenges, not just national challenges, around sustainable development. We have seen a shift in thinking amongst some of the policymakers globally in competition authorities, recognizing a role for pursuing other social objectives with competition law. And often this is more typically limited to their own jurisdictions. But even though, as Doris Tsepe has pointed out, these G20 authorities typically only have national jurisdiction, they do oversee the largest and most powerful multinationals that shape global markets and shape whether we have inclusive growth and address some of the global challenges globally. Another, as Andrea pointed out, is through advocacy. Competition authorities are typically very powerful advocates for for improving the efficiency of government regulation and also improving outcomes in markets. So this leads us to the first issue that we wish to discuss today, which is namely how enforcement choices and actions and priorities made by the competition authorities of the world's 20 largest economies can positively impact on the global commons, which we all aim through the UN sustainability goals to address, which include food security, public health care, climate change, and also the technological advancements that will drive better livelihoods globally. We have global organizations such as the ICN, and we have just heard from the ICN chair, and they do facilitate the exchange of best practice. They provide a forum for debate around enforcement issues. And whilst they're not specifically designed as a forum for discussing a common enforcement agenda, what we have seen is that they have the potential to play exactly this role. In its recent history, the ICN has played a role in promoting enforcement in digital markets based on common concerns around global dominance shared by many authorities, and that coordinated action has delivered results. We've also seen in this period the authorities under the G7 banner also looking to coordinate their enforcement agenda on digital markets by providing regular updates amongst each other. We've also seen in regional enforcement contexts, such as with DG Comp, concerns such as climate change being pursued across a group of member countries. And we have in Africa, of course, done the same under the African Competition Forum, and maybe in future more organized through the African Continental Free Trade Area. So this demonstrates that their positive coordination can occur, but it's not necessarily at the moment focused on some of the big key sustainable development goals that will allow for a more equal economy, not just in individual countries, but across the globe, and address some of the global commons problems such as climate change, food security, public health care, and the AI technological developments. And this leads us to our second set of issues to be discussed today, namely whether that enhanced cooperation and coordination around these key global commons can ensure a larger positive impact on global sustainability objectives and the achievement of the UN sustainability goals. And if so, what might that look like and how can it be achieved? So with those introductory comments for the panel, I'm going to first turn to Mr. Malik Diallo, Head of Competition at the African Free Trade Area, just to give us some opening comments about how that Secretariat is viewing its role and the pursuit of these sustainability objectives.
James, thank you. Thank you very much. At the outset, allow me to thank Commissioner Sepe and convey also greetings to her from the Secretary General of the AFCFTA Secretariat, His Excellency Wamkele. I think this conversation is absolutely timely. Africa stands at a crossroads, implementing the largest free trade area by nation count, while building competition framework that support inclusive industrialization. I think this have been also alluded by the two commissioners that just took the floor before. So the challenges we face on the continent: platform dominance in digital market, input cartels that price small agricultural farmers out of production, pharmaceutical pricing that puts essential medicines beyond reach. These are not unique to the African continent. They are global challenges with local consequences. And these challenges were the decisions made by G20 members of competition authorities. They fundamentally shape outcomes, not just in their jurisdictions, but across also all developing economies. So I just wanted to share some perspectives on how enforcement at G20 level creates global spillover effects. We know by now that G20 competition authorities collectively oversees enforcement in economies that account for approximately 85% of global GDP and over 75% of world trade. The multinational enterprises that are regulated don't operate in discrete markets. They operate globally, including in African markets. So the measures, decisions, cartels investigations, and platforms regulations reshape competitive dynamics far beyond those borders. When the European Commission finds Google $4.3 billion in euros in 2018 for bundling its search engine and Chrome browser with Android device, requiring manufacturers to pre-install these apps to access the Play Store, that decision didn't just affect European consumers. It reshaped how African entrepreneurs and small businesses access digital markets, how apps developers in Nigeria, in Kenya compete, and whether alternative platforms have any realistic chance to enter African markets where smartphones penetration is exploding. Yet this global reach creates an imbalance. African Commission authorities, despite limited resources, must often respond to enforcement decisions made elsewhere. In African markets, African authorities learn about major measures clearance or behavioral remedies after they are finalized and must adapt to realities shaped elsewhere. We all agree that the spillover effect of such enforcement decisions affect developing economies, and these economies are deeply integrated into global value chains. I just wanted, James, if you allow me, to give some concrete examples of where these spillovers matters most. Let me take agricultural input markets. When G20 authorities break fertilizer cartels or investigate agricultural technology monopolies, farmers in Kenya, Nigeria, and Egypt benefit directly through reduced costs of inputs. Conversely, when the fertilizer cartel operates in Europe without sufficient enforcement action, those same practices often flow through to Africa via the same multinational actors. The second example is digital platforms. When G20 authorities set major threshold or impose interoperability requirements on digital platforms, these directly affect how African small businesses access markets through e-commerce and digital payments. A G20 decision to require data portability or interoperability in one jurisdiction creates cascading effects in Africa, either supporting or constraining competitive entry. And when it comes to pharmaceutical markets, high-value drugs priced in Africa often reflect decisions made by G20 authorities on generic competition in their home markets. For instance, when the US FTC or DOJ review a pharmaceutical measure, they rightly focus on US markets competition and US consumer welfare. But the major entities' decisions about production volumes, generic licensing, patent enforcement, those decisions ripple through African pharmaceutical markets. So here in the continent, at the AFCFTA Secretariat, we observe both positive and negative spillovers. When G20 authorities tackle international cartels affecting critical inputs, this strengthens African competition policies by establishing that certain practices will not be tolerated globally. But we also see instances where G20 enforcement priorities diverge from African development objectives, and African countries lack the voice or capacity to redirect that enforcement towards sustainability critical sectors affecting our continent. Given this global impact, it is important that authorities consider the distributive effect of enforcement decisions on developing regions. When reviewing global mergers, they may also assess competitive effect, not only in G20 markets, but also in emerging markets where the same firms operate. When imposing behavioral remedies on global platforms, they could also consider how these remedies might benefit or disadvantage users and businesses in developing countries. When investigating international cartels, they could prioritize cases in sectors critical to developing countries' industrialization and food security, such as agriculture inputs, construction materials, pharmaceutical, and logistics. And we think this approach aligns perfectly with South Africa G20 theme of solidarity, equity, and sustainability. And recognizing that truly global sustainability requires that competition enforcement benefits all nations, not just the world's largest economies. And this is why cooperation, international cooperation, is extremely important. And I think we will talk about that later. I thank you, James. I stop here.
Thank you very much, Malik, for those thoughtful comments. And I just wanted to follow up on a couple of them. I mean, you rightly have pointed out that some decisions can be globalized and have a beneficial effect. But we also see many decisions that are not globalized. So in all our work on digital markets, we are finding ourselves wanting to impose remedies that have already been adopted in the European Union and asking that the companies globalize them. I think you've also raised the issue that that merger decisions, you would want some of the G20 countries to consider the effects on distribution in the global south. And they may answer that, well, in our market, it doesn't have an effect and we only have a national jurisdiction. So I suppose the question to you is, it would seem there's still an important role for strong authorities within other G20 countries and in the global south, and probably authorities such as your own, which have a continental sphere, in order to ensure the globalization of some of these benefits and to ensure that the interests of the global south are taken into account. So maybe if you could respond, that would be great.
Oh, thank you, James. I think it's extremely important. The experience we have seen, and let me take one of the issues that we have tackled in the context of the digital markets, in the perspective of the shaping the competition protocol under the AFCFTA. We have witnessed that since decades now, enforcement in the digital space have been very active from many jurisdictions, whether in the US, in the European Union, in Australia, and somewhere else. And these decisions have given us some lessons that we have learned. And it is what I was saying earlier, that some practices that have been prohibited, whether at ex ante level or post-investigation level, cannot be tolerated also at the continental level. Because we cannot have, let's say, dual treatment for African businesses and African consumers, whether it comes to the African market or European or other markets. So what we have done is try to learn from those lessons and have those prohibitions of certain of those practices in the protocol on competition policy. And of course, these are still work that we are undertaking to refine these provisions, but the basic principles is to send a message that we are, yes, our consumers, our businesses are depending on global multinational digital platforms, and practices that have not been tolerated elsewhere will also not be tolerated in Africa. This is a way to tackle these spillover effects that the decisions may have in Africa. And it goes also to other sectors, as I said, to fertilizer, agricultural inputs, etc., etc. So I think one way to deal with this from our perspective, and the competition authority of the AFCFTA will play a huge role in that, is to have a seat at the table to be able to discuss with those authorities also in G20 members and shape a cooperation framework that will ensure that these issues are taken on board when decisions, whether on mergers or cartels or investigations, are being undertaken globally.
Thank you very much, Malik. And I think that is a good initiative, and I look forward to seeing that move forward. I'm now going to turn to Ms. Tatiana Lima from CADE Brazil. And of course, Brazil is one of the bread baskets of the globe, an important source for minerals as well. And so decisions at CADE do have ripple effects. But let me hand over to you, Tatiana, to give us your perspective on this theme about cooperation for global commons.
Thank you, James. It's a great pleasure to be here today. And as you said, Brazil is an important player in this role. Almost 50% of our territory is covered by the Amazon rainforest. And the forest contains around 20% of world's available fresh water. And as you said, important mineral reserves. And at the same time, agriculture and livestock farming are among the most significant economic activities in Brazil. So in this context, our importance is very clear. And we give importance to that. So as everyone knows, Brazil is hosting COP30, which demonstrate the country's willingness to cooperate with the international community on climate and sustainability issues. But regarding to competition authority, CADE, our mandate is only related to prevent any acts that may harm consumers. You don't have mandate to related to sustainability goals. However, as consumers increasingly value sustainability and environmental responsibility, CADE may, in some cases, consider these impacts on mergers, acquisitions, or company practices. And in this sense, we believe that our role is, as far as possible, to provide the right incentives for market participants. Sometimes, however, we have difficult dilemmas to deal with. And one example is an ongoing investigation at CADE. Soy buyers agreed not to purchase soybeans from producers who cultivated areas deforested in Amazon biome after 2008. For the sustainability, it's good, but when we look these from the side of a competition, what the general superintendents of the CADE concluded is that there were competing private companies that were creating a working group to monitor the market and facilitate an agreement to setting conditions for purchase of soy in Brazil. So it's kind of a buyer cartel. And the general superintendent found that such conduct could be uncompetitive and issued an injunction prohibiting the practice. Some entities, environmental entities involved in the case appealed this decision, and CADE's tribunal reviewed the appeal and decided to suspend the injunction until January 2026. But the final decision is still pending. And on one hand, as I said, our primary mission is to protect competition and consumers. On the other hand, we can consider the potential side effects of our decision on sustainability. And after the judgment of the appeal, a ruling of the Justice of Brazilian Supreme Court has suspended all judicial and administrative proceedings related to this case, to soy moratorium, until the court reaches a final decision on the matter. So this is an example of how difficult it can be to reconcile sustainable goals with competition. But to end my presentation on a positive note, we had other cases where sustainability was at the core of the operation and that were not as controversial. So at the end of 2023, for example, a group of companies in agribusiness and food industries notified CAD of the creation of a joint venture, and they planned to develop and operate a platform aimed at standardizing sustainability measures across the food and agricultural supply chain. In more detail, the platform had the objective to provide a neutral, safe, and secure system through which companies could confidentially input their data and share it only with authorized clients. Provide a data framework to enable standardization and also to measurement capabilities, methodologies, and metrics defined by the industry itself, fostering a more sustainable transformation of the supply chain. And although there were potential theories of harm to be considered in relation to this joint venture, CAD concluded that the project's primary objective offset the competition risks involved. All these decisions, as they are related to Amazon biome, can impact all the world. And so this case highlights the importance of cooperation, sometimes among companies and within countries and across borders. As is in the prospect of this event, cooperation can strengthen our decisions, and collaboration around key global commons can ensure great positive impact on global sustainability goals. Thank you.
Thank you, Tatiana. And I think it is fascinating that you've raised a couple of the cases you have. As you say, Brazil's investigation of that joint venture amongst the global traders had a huge effect on the globe. That's been rolled out now in countries such as our own. And in a sense, you're the gatekeeper to enforce what may have global effects. And it highlights exactly what Malik was saying. Enforcement decisions taken in these G20 countries can have ripple effects. I did want to ask you just one question around you. I think rightly raised this potential conflict between competition and maybe sustainability. And I suppose for some countries or commentators, competition might always be not in conflict with social goals. But in South Africa, our experience has been that sometimes it can be in conflict. And I'm just interested what your view is, whether this conflict can exist and how should competition authorities manage that conflict like you did in the case of the soya limitations?
Hello. I think this is a very difficult matter because we haven't resolved it in Brazil, solved this dilemma. We are still thinking about what to do in this case and in others, because as I said, we don't have a mandate related to sustainability as in Mexico, if I understood well what Andrea said. And what we try to do is protect competition as we have to do, but try to figure out how we can do that without compromising sustainability goals. And you know the importance that Brazil has in these matters because of the forest and everything. But it's something that we don't have an answer until now. And as this case is still pending, and it's really controversial, and it was something that I haven't ever seen in CADE before, because in the day of the judgment, around 20 environmental entities were there willing to speak and to say how important this question was. And it was because of that CAD decided to wait a little and give a time to think and to see what we would do.
No, thank you. I think you're right. These are complex, and I suppose for some countries it may be changing the law to allow that consideration, and for it may also be for those that don't have that in their law to defer from prosecution as another strategy. But let me now bring in Dr. Luca Arnaudo from the Italian authority. And of course, Italy is part of the European Union, where there is, in a sense, collaboration amongst authorities and a super authority. And that probably is a good starting point to also learn about how that collaboration can deepen amongst countries, which I think, as Malik alluded to, consultations that may happen across countries. So, Luca, I'm going to hand over to you to give your perspectives on this important topic.
Very much. Can you hear me well?
We can.
Good morning, good afternoon, good evening, everybody. It's a pleasure and an honor to be here participating to this prestigious panel. At the same time, I cannot but agree more with Commissioner Cepe about the difficulties of the time. I will go back instantly to your very important point about how we do cooperate within the European Union. But as a preliminary statement, I would just refer to the fact that I read with great interest the final document of the G20 Trade and Investments Ministers meeting that was held a few weeks ago at Capeira, where from one side it was striking to read that only most members, but not everybody, were reaffirming their commitments to rules-based, non-discriminatory, open and fair multilateral trading system. And from another side, caught my attention the fact that the same word competition only surfaced once at the very end of the document, and only by connecting it with the adjective fair. So gone are the days, I would say, when free competition was a kind of panacea for everything. Now we have to talk and we have to consider fair competition. It is a call for reassessing the same value of competition, what we do on a daily basis at the competition authorities around the world. And rightly so, I would say. Interesting times require possibly complex solutions, but this is what we are called to do. And yes, it's right. At the European level, national competition authorities, such as the Italian one, where I do work, daily cooperate on a daily basis. There is a so-called European Competition Network, which is working pretty well, I would say, from an enforcement viewpoint. Our decisions many preliminary considerations are preliminary discussed together with the European Commission and other competition authorities, so that we might reach shared solutions for shared problems. From this viewpoint, I would say that, for instance, in the very few months, the Italian Competition Authority did focus on a string of cases that have been preliminarily considered and kept under a shared information network basis with the European Competition Network. I would be more than happy to come back to more details on these cases, but just to consider how fair competition might be well connected with the very fundamental goal of the current G20, which is global commons. I will focus on these first three cases because they touch upon and they nicely connect, I would say, with very different global commons. So first case, in September 2025, the Competition Authority closed an investigation for cartel among the most important oil companies in Italy, the so-called biofuel cartel, setting up a record-breaking fine of nearly 1 billion euros. What happened there? The coordination involved setting the value of a biocomponent included in the fuel price. It is a component that is introduced mandatorily by oil companies within the product to be sold to end consumers, rightly to comply with legal obligations aimed promoting environmental protection and tackling global change. So if you want, it is a very traditional global common. It has been immediately taken into consideration by the Competition Authority. But we have to consider here that there is both a direct consequence for pursuing, supporting this global common, and at the same time, global direct consequence when it comes to end consumers. The price of this component was tripled, and obviously enough, we are now facing pending litigation. We will see how it will end, but it is a case that reminds us how we can directly tackle climate change and environmental protection through the lenses of competition. Another case that I would like to consider, it's a very recent sector inquiry about school publishing. We did publish a preliminary report. It's a bulk report that came out in August 2025. The sector inquiry is due to close within the end of the month, at least for the moment. It's an interesting proceedings also because we are relying upon the so-called new powers, the competition regulatory tools that allow to use sector inquiries in a different way, if you want. My point here is that school publishing is affecting every year in Italy only 8 million students, roughly 1 million teachers. And among the many criticalities that came out, that has been highlighted by the preliminary report, one stands out, which is the licensing conditions for ebooks, for digital contents. And here, the interesting issue is that at least since the G20 held in India in 2023, we now know that education and culture are two of the most relevant global commons. Now, when it comes to licensing digital books, the way we are currently licensed with very severe limitation for the usability for consumers, for the sub-sale of this license and so on, this is not only an issue related to competition and consumers' protections. This is affecting the possibility to rely upon these resources when it comes to education. So again, there's a connection here between how to protect and enhance competition and how also to further develop global commons such as education. The Competition Authority is heavily involved in finding a solution for this, so we hope to deliver a response to this issue pretty soon. It is interesting to note that we opened a public call for consideration of this preliminary report. And we did get answers from all around the world. Universities from all around the world, from United States to European Union. Many Italian universities even created consortia for answering to our call. NGOs and open society, I would say, from all around the world were pretty much interested in considering the results of this preliminary report, which explains us that when competition authorities do tackle certain issues, the value of competition, of fair competition, comes up and stands out at a global reference level. Final case I want to briefly consider, it's an abuse of dominant position case that has been opened in July 2025 against Meta for a case for a behavior referring to its chatbot Meta AI. The issue here is that Meta pre-installed this Meta AI app within WhatsApp without a prior consent by consumers. And in the authority view, there is a risk for consumers to be locked in, to remain functionally dependent by this app, and also that Meta might use information provided by consumers over the time to get a competitive advantage that could not be replicated by competitors. So the proceeding just opened. We are expected to close it at the end of December 2026. Again, my point here, as we are talking about global commons and priorities of the G20, we all know how much data governance might be relevant when it comes to global commons. There are even very interesting scholarship productions related to the fact that data themselves are a global common, and the government, it's an absolute priority to be considered. We can do it as competition authorities. We can contribute as competition authorities through our activities. And this string of cases was just an idea that I could provide from our Italian observatory. I would stop here, but open to question.
Thank you, Luca. And certainly I can say as an economist, we are big fans of some of the work the Italian authority is doing. You didn't mention some of the important work you've also done in pharmaceuticals, which we have followed and learned from. So I do applaud you. And I think it is fascinating to see how you're getting global commentary on some of these cases, which is exactly what Malik was sort of talking about how do you bring in the views of others globally on some of these issues. But I wanted to pick up one aspect that has also been highlighted in that trade and investment statement, and is about that sometimes pursuing your own interests as a country can have negative consequences for others. And I suppose building multilateral systems are trying to find that shared benefit and grow the pie. And just within a competition realm, you have that experience within the ECN, as you talked about. I mean, are there times that some of the cases could harm Italian interests, and how do you resolve that with your colleagues across the ECN, just from a competition perspective, prioritization perspective? It would be interesting, I think, for others to hear on that. Thank you.
Can you hear me now? Okay. So, tough question, to say the least. Very interesting one. The priority setting is a pivot for every competition authority. As we are part of the European competition network, every competition authority is obviously free to follow its own agenda, but at the same time, I could not deny there is a useful confrontation when it comes, for example, for cases that might raise on the surface of a given member state of the European Union, but might also affect other states. So even before to start an investigation, there might be a way to consider together how to cooperate, how to align to a shared standard for what it comes, for example, for case design. As you rightly mentioned, there might be cases when these interests do not align. We did have in the past cases with different conclusions, very similar opening proceedings, and then different way to deal with them. Or even, as you did mention, the case of pharmaceuticals, where Italian Competition Authority has been traditionally pretty much involved. Just to remind the case, we did use the interpretation of Article 101 for the Roche Novartis case, whereas the French Competition Authority did prefer to consider it as an abuse of dominant position. Where is the right point? Possibly both cases are right, because when we tackle global issues related to competition, many different views are possible. The important goal to my side, at least, is to reach an effective conclusion of a case that enhance competition and allow consumers to find a better way to deal with a market. It's a dynamic issue that has no final answer. For sure, cooperation and at least attempt to coordination are fundamental. We are part of the European Competition Network, but we are also part of the International Competition Network, and we cannot but wait for enhanced cooperation when it comes to this broader level.
Thank you very much, Luca, for those insights. And certainly, I think Malik and his colleagues at the African Continental Free Trade Area Secretariat will be able to draw on some of those lessons. Before I introduce our next panelist, it's just a reminder to the participants that if you want to post a question to the panelists, please use the chat feature that is open, and you can send that, and I will take some of those questions and put them to the panel. But moving next to Mr. Andrei Tsiganov, the Deputy CEO of FAS Russia. Certainly, Russia has been a very active member of BRICS, which is another forum that has pushed some of these sustainability and development objectives. So I'm sure we're all interested to hear your perspectives on this global commons and how we might address it collectively.
So, hello everybody, and thank you, James, for letting me to speak. And dear colleagues, I'm very happy to have this opportunity to speak at the competition policy workshop held within G20 trade and investment track under South Africa's presidency. Yes, and yes, all of us know clearly that 17 Sustainable Development Goals are not only about climate changes, but also it's food security, improved education, high quality healthcare, safe information technologies, and so on, so forth. And we truly believe that competition policy tools and that regulators currently have, and that regulators elaborate during their everyday work, can make a significant contribution to achieving United Nations Sustainable Development Goals. A few words about Russian experience. Yes, the FAS pays great attention to finding a balance between sustainable development and compliance with anti-monopoly legislation. And some speakers before me just mentioned that it could be a conflict, but we try to find this balance in all cases we have. And our activity, our competition policy is based on the provisions of Russian competition law and on the decree of the President of the Russian Federation on the main directions of state policy for the development of competition that was adopted in 2017. And this decree is not about us. It's not about Federal Anti-Monopoly Service. It's about one important direction of state economic policy in our country, because it consists of a set of measures not only for competition authority, but for industrial ministries, for ministries of education, for media, for courts, and so on and so forth. And a current guiding document for our strategic planning while implementing of this decree of the president is the National Plan for the Development of Competition for 2021-2025. But now, this year, the national plan for the next 5 years, from 2026 to 2030, was approved by the decree of the government of the Russian Federation. And this is a very important document that was elaborated as a part of a bigger national project called Effective and Pro-Competitive Economy. It's one of the main directions of activity of the Russian government. The plan includes a wide set of measures in 8 economic sectors: in agro-industrial complex, in IT and telecommunication, financial market, healthcare, transport, industry, trade, tourism. And these measures are both industry-wide and aimed at development of competition legislation and enforcement, such as identification and combating cartels, development of competition development roadmaps on the level of the regions of the Russian Federation, implementation of preventive mechanisms to combat discrimination in access to grids, to the infrastructure of the Russian Federation, and of course extended cooperation with the antitrust authorities of BRICS countries, of Commonwealth of Independent State countries, of countries of Shanghai Cooperation Organization, and so on and so forth. And further, I'd like to tell a few words about measures and activities that Federal Anti-Monopoly Service is currently taking to contribute to the achievement of Sustainable Development Goals in some sectors. Yes, and just in the beginning of our meeting today, Commissioner Chepe stressed one very important idea, that competition policy should bring tangible results for people. And that's why we continue to pay closer attention to the development of competition and control over anti-monopoly compliance in so-called socially significant markets. And talking about SDG 2, we continue to work on agricultural and food markets from the point of view of development of competition. We pay much attention to pricing of socially important food commodities. And yes, of course, it includes the monitoring of the situation on the market on the everyday basis. And very important that when checking prices and situation on food and social import market, we look at the entire value chain, starting from mineral fertilizers, seeds, plant protection products, and to the shelf on the retail outlets. And such measures that we can in our toolkit could be preventive, like warnings addressed to businesses, or we can initiate cases of violation of competition law. And we paid much attention to the soft law tools. For instance, to increase the affordability of food products for citizens and promote food security, the Federal Anti-Monopoly Service suggested producers and retail chains take social responsibility behavior and take on voluntary obligations to limit their own prices and markups. And it's important that this soft law mechanism, the propaganda of pro-competitive behavior, works. And as a result of this, advocacy, first of all, activity and negotiations activity, now 50 federal and regional retail chains have joined these initiatives, and these chains control nearly 70% of Russian food market. And prices for socially significant products like buckwheat, bread, sugar, sunflower oil, chicken meat, and so on are kept below the average market level. And moreover, as a result of this policy, margins on so-called essential goods in retail sector decreases from 22 to 4%. It's very, very important step forward to the normal level of food prices in Russia. And strategic development, sustainable development goal 3. We pay great attention to the pharmaceutical sector in order to provide population with sufficient quantity of medicines, eliminate unjustified price increases, increase range, and improve quality of medical care. And we conduct, we have in Russia a specific price setting mechanisms. We have a comparative analysis of prices for essential medicines with their prices in referent countries. And last year, the Federal Anti-Monopoly Service analyzed 11,000 prices for medicines declared by manufacturer, and based on the results of this analysis, nearly 900 product prices were reduced by an average of 15 or 20%. And Sustainable Development Goal 4, turning to the Lucas speech, yes, we have, this year we made a decision on very important and interesting case on school book case against one of the biggest publishers in Russia. Sustainable Development Goal 9, digital markets. Yes, we pay a lot of attention to development of digital markets, and just 2 years ago, the 5th anti-monopoly package of amendments to the competition law came into force, so-called digital set of amendments. And now we're already working on the 6th anti-monopoly package, which proposes to address the practice of unfair using of intellectual property rights that is especially relevant for digital market and as well as for pharmaceutical markets of our country. And Federal Anti-Monopoly Service work on all these areas of activity, and at the same time we try to introduce the digital solution in our own everyday practice. And one of the main steps forward is the anti-cartel system, because this year the law on the creation of anti-cartel system as a part of competition legislation in Russia was signed by the President of the Russian Federation and entered into force in August this year. So, and a few words, if you let me, James, about cooperation of competition authorities. Yes, to strengthen international cooperation is very important for achieving SDGs, because SDGs is a global, large-scale task. And talking about this, we think that achieving global sustainable development goals requires multi-format practical cooperation between different stakeholders with the involvement of our counterparts from the Commonwealth of Independent States, BRICS, Shanghai Cooperation Organization, ASEAN, and together we study problems. It's practical work. Find answers to challenges and cooperate on specific cases, exchanging approach, experience, and the best practice. And from our point of view is the more effective way than to organize a sort of a competition enforcement czar, global enforcer or regional enforcer to share experience with us. But we have the example of sharing our work with multinationals as well. For instance, Russia is a part of Euro-Asian Economic Union, and Euro-Asian Economic Commission have a set of their own power on transnational transborder markets in the framework of the custom union of the countries of Euro-Asian Economic Union. And you mentioned BRICS. Yes, from our point of view, the global sustainable development goals are in the line with the task we have set within the BRICS working groups for the research of competition issues in socially significant market. Working group for research of competition issues in digital market. This group addresses current competition issues arising from the rapid development of digital technologies and artificial intelligence. Our working group on pharmaceutical market is concentrated on the study of competition issues in biosimilars market. Biosimilars is the future of pharmaceutical industry from our point of view, and it should be developed on the pro-competitive basis. BRICS working group on food market focuses on issues of competition regulation in agricultural market, improving food security in BRICS, and sustainability of global food value chains. So we have different direction of cooperation with our counterparts. We use different contacts, different sets of joint goals. And what's important that we pay a lot of attention to the interconnection of cooperation platforms and formats of cooperation.
No, thank you, Andrei. I'm just going to thank you for the comprehensive.
Okay.
I'm just mindful of time, and I just want to bring in Dr. Hisham Alugil.
Thank you.
But thank you for that. And I think you've highlighted very well that there are sets of interconnecting groups.
Yes. Yes.
And there's not one competition czar, as you put it, over everything, but it's those different groups that may play different roles. And
Yes.
our last panelist is Dr. Hisham Alugil from Saudi Arabia, the Deputy CEO of Economic Affairs. And Saudi Arabia is also one of those that is part of many groups, BRICS, G20, and Association of Arab States. So Dr. Hisham, I just want to invite you to give your perspectives on this issue of the global commons and how you see it coming from the perspective of Saudi Arabia.
No, thank you very much, Mr. Hodge, and my sincere appreciation to the South African presidency for convening this important webinar. To start, I join other speakers in emphasizing the role of competition in promoting investment, innovation, and inclusive growth. Of course, competition policy at its core is about fairness, openness, and shared prosperity. It ensures that markets remain dynamic, inclusive, and capable of delivering opportunity for all. We all recognize that in a hyper-globalized, hyper-digital world, the interface between competition, trade, industrial policy is an imperative but complex topic that needs international dialogue and cooperation. Private anti-competitive practice can indeed distort trade and pose barrier to market access, which cause great economic and consumer harm. As a result, ensuring a leveling playing field is crucial for proper functioning of the interconnected market and the structure of entire global value chain. In this regard, I think bringing this topic and the importance of competition at the G20 level is very important in supporting competition authority. As the concept note mentioned, competition authority can indeed shape and safeguard the global commons. However, it is important to recognize that this poses challenges and need careful and balanced approach. while in principle, competition authority soft action, whether it's against cartel behavior, abuse of dominance, or anti-competitive merger, could in some cases contribute to sustainability. It could lead to unintended consequences. That include inefficient allocation of resource, higher cost, stifled innovation, and most importantly, potential for political instability and conflict. We live in a time where uncertainty is high and global challenges are too complex, and no single authority can confront this alone. As a result, the role of cooperation and coordination among our authority as competition guardian is equally important. International fora such as OECD, ICN are important platform to balance different objectives. In addition, this cooperation will also promote capacity building among members on more technical issue, which I think this is more challenging aspect, including adapting and advancing economic tools to analyze this topic, and especially the dynamic analysis that take into account long-term gain and efficiency. So let me turn to our perspective. Our experience demonstrates how a regional cooperation can be a powerful tool for amplifying enforcement capacity and promoting sustainability. As a chair of the Arab Competition Network, we work closely with 15 member states to cooperate in the Middle East and North Africa. The Arab Network have helped establish a community of practice, one that addresses analytical tool, case experience, and insight among members. And beyond capacity building, it has fostered trust, which is a true currency of effective cooperation. In addition, we are currently exploring cooperation with international organizations to launch important initiative and program for the MENA region, with the objective to enhance technical capability for the competition authority in the MENA region. So let me now turn into more local and national level our effort in the sustainability agenda. We introduce programs that encourage enterprise to adopt internal compliance and raise their awareness of competition law, especially in the exemption process and procedure from the law, including any efficiency gain that could be looked at from a competition perspective. We also work to enable form of legitimate cooperation among business that contribute to technological development, research, and innovation in a way that enhances sustainability. This year, we launched a guideline on dealing with horizontal and vertical agreement, which clarify the rules governing research and development agreement as a model of economic collaboration that can achieve productive efficiency and foster innovation of product and services. This guideline reflects the authority commitment to balance the protection of competition with the encouragement of constructive cooperation and support sustainable economic growth. In this regard, maybe I mention one case, merger case in steel industrial, which has been controversial in our discussion because it will increase really the market share. However, taken into account the efficiency, the benefit that will gain from this merger, we approve the merger without any condition. So let me conclude by thanking you again, Mr. Drog, for the opportunity to contribute and for advancing this important dialogue toward a more competitive and resilient global economy. Thank you.
Thank you, Dr. Alugil. I think, as our last panelist, you've touched on a couple of things that are I think, more are particularly interesting, such as the issue of cooperation amongst firms to achieve some of the sustainability goals that may not be harmful to competition. And it's always a reminder, I suppose, for competition authorities that some degree of cooperation can be beneficial, even if other forms are harmful. But also the power of regional groups to I suppose, deepen the cooperation, which is not always possible at a global level. And the interaction between those regional groups is probably a foundation for that global dialogue, as you pointed out rightly. We are unfortunately out of time, so I can't take any of the questions from the participants, but I would like to thank the panel members for their thoughtful insights. And I think it also shows the benefit of having a globalized group of panelists to get the different perspectives, different challenges, but where there is a shared objective around improving sustainability and furthering the sustainability goals. So with that, I'm going to sign off and hand back to Commissioner Tsepe to end this webinar.
Thank you so much, James, and to the panelists. I think this was a very useful a conversation, a discussion for us to have. I think for me, the discussions have highlighted, I think, some of the importance of discussions at a global level that we all need to have in order to have the outcomes we want to have. I think the panelists highlighted the importance of shared solutions for shared problems. And I think that was Dr. Luca who raised this. And I think it's such an important issue because, as we all have agreed, the global nature of markets and commerce and business means some of the problems we have that we are trying to solve are shared and similar. And so we need to, as competition authorities, consider how to protect and enhance competition in markets while also promoting global developmental goals. And this underscores the importance of building strong multilateral systems to enable the realization of the shared goals. Andrea reminded us, I think, that we need to recognize that competition law does not exist in isolation. And I think we raised this right at the beginning, that alongside trade, alongside industrial policy, competition law should be another way of policy intervention to enable us to get economic strategies that solve global problems for all of us. Cooperation with sector regulators and other government stakeholders is also important for ensuring that markets are contestable and lead to tangible benefits from competition. International cooperation is absolutely crucial, given, as I stated, the interconnected nature of business today and the challenges that face competition authorities. Looking at markets that impact particularly low-income consumers in agriculture, in food, in pharma is absolutely critical. And so I think in closing, I would like to say we need to make sure that competition policy remains more stronger, agile, and impactful for all our economies. I wish to thank you, to thank our panel and our moderator and all of you for joining us on this important conversation, and we hope to have more of them. Thank you so much, James, and to the organizers. Thank you.